Hmm? I don't know. Jefferson County Court at Law number 2 is back in session. Court is in session in cause number 23 CCCV 0639. Case is styled State of Texas versus Yolanda Michelle Chapman. Ms. Chapman, is that your full name?
Yes.
Ms. Chapman, would you please raise your right hand? Ms. Chapman, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Ms. Chapman, you may put your hand down. How are you doing, Ms. Chapman?
Fine. How are you?
I'm doing fine. Thanks for asking. Now, Ms. Chapman, I have before me, in this case, a petition for order of non-disclosure under section 411.0725. And in your petition, it alleges or it states that you was charged previously with the offense of theft. They have theft by check, a misdemeanor offense in criminal cause number 317336. That was the case number that the theft charge was in. That's what it here has in its petition. Now, to verify that, I have a copy of the is that it? Yeah, I have a copy of the deferred adjudication order. And in this order, it states, and this order is attached to the paperwork. This order is attached to the petition that you filed. Okay. Now, in this petition, or in this order, it states that the cause number is 317336, and that you, Yolanda Michelle Chapman, on September 10th of 2018, that you were placed on deferred adjudicated probation for the Class A misdemeanor offense of theft. Okay. So it also states in this petition, actually, that this deferred adjudication order is attached. It also states that the court did not proceed with adjudication, instead discharged and dismissed the proceeding against the petitioner. And so we also have a copy of a deferred adjudication order of dismissal. And it states here that on June 21st of 2021, you were discharged off of deferred probation. And that is also attached. Your petition further states that petitioner satisfies the requirement of section 411.0725, in that petition satisfies the requirement of 411.0725 of the government code, in that petition is not eligible for an automatic order of non-disclosure under section 411.072, because, and under D is checked, the petitioner has been previously convicted or placed on deferred adjudication for an offense other than a traffic offense punishable by a fine only. And so because you were not eligible under section 411.072, you're able to proceed under this section 411.0725. Your petition also state that, okay, on or after the discharge and dismissal, on or after discharge and dismissal, if petition offense is a misdemeanor other than a misdemeanor offense of penal code. That one has a That doesn't make sense, just on or after the discharge or dismissal. I don't know, something must be missing.
Well, the one I had, it said after 2 years, I was able to do a non-disclosure after 2 years of completing.
Okay, and you completed the probation in 2021? Yeah. Yeah, this is 2024, so you've been beyond that. But what I was looking at, I was reading in the petition, right here where it's checked, it says on or after the discharge and dismissal. That's all it says. Well, let me read. They say, finally, petition satisfies the requirement of section 411.0725 in that petition has waited the requisite time as indicated below before filing this petition on or after the discharge and dismissal. Okay, so basically you're saying that you've met the waiting period, the 2-year waiting period. You're filing this after the 2-year waiting period. Okay.
That's what I got when I was releasing, you signed up on, I got it from downstairs.
Right.
That's what they had on there, so I had to wait 2 years.
Right. So the petition satisfies the requirement because on after the place of deferred education and applicable period, petition has not been convicted or placed on deferred adjudication for any offense other than a traffic offense punishable by fine only. So you have not had any convictions since being placed on, since completing this probation. Petition has not ever been convicted or placed on deferred education for any offense listed below. And there was several offenses listed below, but if you have never been convicted, none of these offenses are applicable because you have not been convicted. Is that correct?
Recently, no.
Right. When you say recently, I'm talking about after you was discharged off of probation. The court has not made an affirmative finding that the case for which okay. No, this is not a family violence offense. The person is entitled, if the person was placed on deferred for a qualifying misdemeanor, you were, if not, eligible to receive an order of non-disclosure under section 411.072 government code. Check. Has received a discharge and dismissal from the court. Check. Has waited the requisite period before filing petition for an order. Check. And has met the eligibility requirements of 411.074. Check. The issuance of order is in the case would be in the best interest. Now, Ms. Chapman, why would it be in the best interest to grant you this non-disclosure?
So I can go back to work.
Okay.
My previous job didn't background check, so.
Okay. Okay. And let's see the fee. Okay. And the fee to file the petition has been paid or otherwise satisfied in that a statement of ineligibility to afford payment of court costs in lieu required of the filing fee. And you have you have an inability to pay, is that correct? Okay, now in your petition, the ineligibility to pay, prior to signing these documents, is everything in these documents true and correct to the best of your knowledge? Okay. State, you have any questions or comments?
The timeline in this case is appropriate. The state does not see any further convictions or deferred adjudications following this case. The one thing the state wanted to clarify is that the case in which Ms. Chapman was placed on deferred adjudication in 2018 for was a theft class A case, not a theft by check case.
Okay, now Ms. Chapman, I guess you can have what is called a trial amendment, in that you can amend your petition. In essence, if you're saying that it is a theft case and you would like to correct, you would just correct this by saying that it's a theft case instead of a theft by check. Because all of the paperwork that we have on the criminal case shows that it's a Class A theft, not a theft by check. They're two different things, two different charges, or two different offenses.
Okay,
Theft by check is when somebody write a high check,
okay,
okay? But a theft is not necessarily writing a high check. If it was been a high check, it would have just been a theft by check. But if somebody took something, it's classified as a theft.
okay.
Now, is it, your case was a theft by check or a theft?
Yeah.
Theft. Okay, so would you like to, are you asking the court to amend your petition to make that correction?
So that's what it was based on. It's been over 2 years, so it was actually a theft, right?
Right.
Yes.
Okay, so yeah.
You want to amend, okay, so what the court is gonna do, the court will amend the petition, the court will grant a trial amendment. You have any objections?
No, Your Honor.
Okay, no objections. And I'll initial it. And Ms. Chapman, I'm gonna give you this document. You see where my initials are? Do you have a pen we can give her? So you can just initial next to where my initials are. Okay. And so you're just doing it, having a trial amendment to this petition. So, other than that, the state is not opposed to the granting of this petition for non-disclosure. The court is going to, sign this petition. The court states that on this 21st day of February of 2024, the court considered the petitioner's petition for order of non-disclosure as related to the following offense. You have a, never mind, I have one. And in this, in cause number 317336 for the offense of theft, the date of the offense. Make sure I got it correct. August 5th of 2017. The date of arrest was on or about February 15th of 2018. Arresting agency, Beaumont Police Department. The county was Jefferson. And we have a TRN number. I'm not going to read that into the record because we are live. The state was given notice of this petition and an opportunity to request a hearing. The state did not request a hearing. However, the court conducted a hearing on February 21st of 2024. After consideration and a hearing, if a hearing was held as indicated above, the court finds that petitioner is entitled to file a petition for an order of non-disclosure under the section of the government code indicated below, and that issuance of an order of non-disclosure is in the best interest of justice. And we're going to check off Texas Government Code section 411.0725. Accordingly, it is hereby ordered that the criminal justice agencies are prohibited from disclosing to the public criminal history record information related to offense detailed herein. It is further ordered that the criminal history record information pertaining to the arrest and prosecution petition for the offense detailed above shall be sealed and disclosed only to individuals or agencies listed in section 411.076A Government Code. It is further ordered that no later than the 15th business day after the date of this order is issued, the clerk of the court, hereafter clerk, shall send all relevant criminal history record information contained in this order or a copy of this order to petitioner and the Criminal Record Service of the Texas Department of Public Safety, hereafter DPS by certified mail, return receipt requested, or secure electronic mail, electronic transmission, or facsimile transmission in accordance with Section 411.075A of the Government Code. It is further ordered that no later than 10 business days after receipt of relevant criminal history record information contained in this order or a copy of this order from the clerk, DPS shall seal any criminal history record information that is the subject of this order and follow the information or a copy of the order to the state or federal agencies listed in Section 411.075B, Government Code, by certified mail, return receipt requested, secure electronic mail, electronic transmission, or facsimile transmission in accordance with Section 411.075B, the Government Code. It is further ordered that an agency or entity shall seal any criminal history record information maintained by the agency or entity that is the subject of this order no later than 30 business days after the date the agency or entity received relevant criminal history record information contained in this order or a copy of this order from DPS or a clerk in accordance with Section 411.075D of the Government Code. It is further ordered that the clerk shall seal all court records containing information that is the subject of this order as soon as practical after the date that the clerk sends a copy of this order or all relevant criminal history record information contained in this order to DPS in accordance with Section 411.076B of the Government Code. Signed this 21st day of February of 2024, Honorable Judge Terrence L. Holmes presiding. Okay. Now, Ms. Chapman, for signing this order, you should be able to get a copy of this order from the county clerk's office, which is right below this court on the first floor. And Ms. Chapman, congratulations. And Mr. Hubel, I need, there's a spot on here for you to sign as well. Lay down there. And we have you have Yolanda Michelle Chapman, aka Yolanda Michelle Chapman. Okay, Ms. Chapman, congratulations. You have a blessed day.
How long I wait to go downstairs, like a couple of weeks or something to get it?
Oh, maybe
The end of the day,
end of the day or tomorrow.
let's make the play say tomorrow.
Yeah.
You need a certified copy, they would have to do that, and I think it's an additional $5 or $6.
Okay, then this, okay, we didn't have any bond forfeitures. This will conclude the calling of the court's announcement docket, the motion to revoke probation docket, and our non-disclosure docket. All three dockets were scheduled today in County Court at Law number 2. Everyone, please have a blessed day.